Good morning. My name is Oksana Bilobran, and I am with the Office of Immigrant and Refugee Affairs, City of Seattle, and I am happy to welcome you here on a Monday morning. Of course, we all wish there were some better news to get us together in a room like this, but we're here to discuss public charge rules that go into effect today. And we're doing this presentation in partnership with Northwest Immigrant Rights Project. And I would like to start by saying thank you to the City of Seattle, the Mayor Durkin, and the City Council for providing resources to address some of the issues that we expect will come up in this year, hopefully last year of Trump administration. Public charge is one of the big issues that affects a lot of immigrants in Seattle, but also across the nation as well. Our Office of Immigrant and Refugee Affairs, is coordinating response to those issues. And in addition to this workshop today, we have a number of events that are targeting clients across the city and King County as well. They will be held in the City of Seattle to explain the rules that go into effect. So if you're interested, or if you have clients who have more questions about these issues, please visit our website, and it is seattle.gov/OIRA. Couple logistical issues. I would like to tell you that we have interpretation available in Spanish for those who request it, but also if you just think you need it. We have an interpreter in the back right there, if you can raise your hand. So feel free to sit at that table. If you want coffee or water, it's over there. Help yourself. We're doing the recording of this event. So Joaquin over there is doing Facebook Live, so please try not to cross in front of his phone too much. We also have a Seattle channel doing a recording of this event, and we will have links to both recordings available on our website. So as I said, live streaming is happening right now, and the link should be available very shortly after, and Seattle channel's recording will be available a couple days later also on our website if you want to check it out later. We have some handouts over there, including the slides. Feel free to grab them to take your notes. And we will email all of those handouts to you if you registered and we have your email. I believe that's it from me. And Jose, do you want to say?
Buenos días. Para los que necesitan intérprete en español, tenemos un intérprete aquí atrás alzando la mano, entonces si necesitan interpretación, por favor pasen atrás. La presentación va a estar dada en inglés con nuestro amigo aquí, Jorge Barón de Northwest Immigrant Rights Project, y los queríamos invitar esta mañana de la ciudad de Seattle a esta presentación.
And I would like to acknowledge all of my fellow OIRA staff members. If you can, guys, raise your hands. So if anybody has questions about any of our programs or work that OIRA does in the community, please feel free to come to us and ask questions. And with that, the restrooms, good point. So the restrooms, you would have to walk out of the room, turn left, and I believe ladies' restroom is in that corner of the hall, and a man is in that corner. And with that, I'm going to pass it on to Jorge Barón from Northwest Immigrant Rights Project.
All right, thank you. Thank you, Oksana. Thank you. I want to first of all thank all the staff from OIRA for helping make this possible. I'm impressed that they actually managed to plan it for the very day when the public charge was going to go into effect. I'm wondering if they have some connection with DHS that we don't know about, knowing exactly when that was going to happen. I'm just joking. Listen, I have to say that I'm a little torn about being here, frankly, because this is a day that many of us in the immigrant rights community hoped would never come, that this rule would go into effect, but it is going into effect today. And the one thing that gives me hope, frankly, is to see all of you here early on a Monday morning. I'm impressed by all of you being here, so I want to thank you for that, to learn more about what this means and how it's going to impact immigrant community members. I want to share So as you heard, there's folks who are recording the session and we're streaming. And so we're going to wait to do the Q&A until the very end. So I realize that you might have questions during the presentation, but just in order to make the recording go better, we're going to wait until we start the Q&A session. And I'll try to make sure that we have enough time for a robust Q&A session because I realize we may not get to cover everything that you want to hear about during the main presentation. And we are going to go kind of straight through. So if any of you need to take a break in the middle, feel free to step aside. I won't be offended by that. But because we are recording, we're just going to go straight through because we have a lot to cover. So I want to start by just for those of you that don't know a lot about Northwest Immigrant Rights Project, just want to make sure that you understand where we're coming from in this conversation. We're a nonprofit organization that provides services statewide. Our focus is in providing immigration legal assistance to people who are navigating the immigration system. Many of the things that we'll talk about today, most of our work is serving individual clients. Again, throughout the state, we have 2 offices in Eastern Washington, in Wenatchee and Granger, and then we have an office in Tacoma, and our main office, which is just a couple of blocks from here. And towards the end, I'll give you more information about how you can refer people and our phone numbers, et cetera. So it's just a quick overview to make sure you understand who is talking to you today. Let me give you a quick overview of what we're going to be talking about today, just to get a sense of where we're going to go. I'm going to give a very brief overview of the immigration process, and the reason many of you in the room, I understand, know about this process, but I think it's important for those of you that are not as familiar to understand a little bit of the different pathways that people have to be able to gain immigration status, because you need that background to be able to understand how the public charge rules apply. And then we'll get into the public charge discussion and spend most of our time focused on that, understanding what it is, what the changes are that are going into effect today, and then probably the focus of attention. And one of the things that I'll mention is that I think in some ways, as we'll discuss, a lot of the attention the last few months over this has been about the impact that the receipt of public assistance or public benefits can have on community members. And as we'll talk about today, there could be an impact, but I think most of it has been the chilling effect, because in reality, the way the rules are going to be applied, the receipt of public benefits is actually a very small portion of the impact. There is going to be a big impact, and I'll try to make sure that you understand what that's going to be, but it's going to be because of other issues beyond issues of receiving public assistance. And then we'll cover a little bit, and this is going to be a complicated thing, and I wanted to sort of lay out from the very beginning. I think one of the most difficult things that we've been struggling with is exactly what the message to the community should be, because I think a lot of us want to be able to sort of send a message of reassurance and to make sure that people feel like they're not everything's okay. But I think the reality is that the message is going to be a lot more complicated, and so I want to sort of start off with that expectation. If you came today hoping that you were going to be, super clear on exactly what's going to happen, I'm afraid that there's still a lot of uncertainty, because one of the big factors is how they're going to apply some of these rules, and so some of it we'll just have to learn to see how the government is actually implementing some of these rules, but we'll get into more detail on that. And then at the end, we'll cover some resources that are available beyond the presentation and places where you can refer people who have additional questions, including our organization. And then, of course, we'll spend some time on the Q&A session. All right? So let's get started with this very quick overview of the immigration system. And let me just say that I'm going to try to cover it in like 10 minutes, what sometimes I spend like 2.5 hours covering. So understand that this is a very, very shortened version of our immigration system. First, I'm going to talk about just very quickly names of agencies, because I know those of us that work with on the immigration system know all these acronyms, but some of you may not be as familiar. And so just a quick reminder of some of the immigration agencies that deal with the immigration system that we'll cover. So there's agencies in the Department of Homeland Security, or DHS, and this is all the federal agencies, by the way. And so there's U.S. Citizenship and Immigration Services, ICE that you might hear about, and CBP, that's Customs and Border Protection. Most of the time today, I'll be talking a lot about USCIS. That is the agency that receives applications here in the U.S. For people who are trying to navigate the immigration system, green cards, citizenship applications. So when I refer to USCIS, it's that component of the Department of Homeland Security. There's also other agencies that are involved in the immigration system through the Department of Justice. There's an office called the Executive Office for Immigration Review that runs the immigration court system. And then I'll also talk briefly about the Department of State. And the Department of State is involved with people who are applying for visas, including applications that are often referred to as immigrant visas, meaning people are going to come as green card holders abroad. And so the Department of State runs those systems. And you might think, well, that only applies to people who are outside the U.S., and that's true. But as we'll talk about, you'll hear about how some people who are living here have actually to leave the country and do their processing outside the U.S. And so the Department of State also is important to keep in mind for people who are even already here in our community, because some of them are going to have to deal with the Department of State, even if they've lived here sometimes for a long time. So when we talk about a quick sketch of terminology when we talk about the immigration system, and again, this is a big simplification of a very complex system. So when we talk about the immigration system, most of my conversation today is going to be about people who are not citizens, who are not yet U.S. citizens, and who are in the United States. So for a second, let's just say that U.S. citizens are people who are born in the United States, who naturalized, who have acquired citizenship at birth because their parents were U.S. citizens. And so we're going to be putting that group of people aside for a minute and focus on people who are not yet U.S. citizens. And if you talk about people who are in the United States right now, and who are not U.S. citizens, there could be literally hundreds of categories of immigration status that somebody can have. But I'm going to focus and put them onto three different categories that we'll talk about today. The first one that we're going to talk a lot today is green card holders. Those are people that in immigration law are known as lawful permanent residents. Those are folks who have been given permission by the government to stay here essentially permanently, although there are ways that you can lose your green card. We'll talk a little bit about that. And folks who can work, and they can eventually apply for U.S. citizenship. They're not required to apply for U.S. citizenship, but they're eligible to. And really, with very minor exceptions, most people are going to have to become permanent residents if they want to be able to eventually become U.S. citizens. Note that I put people who are asylees or refugees in that category because there's a kind of a clear pathway for them to be able to become lawful permanent residents. And so I'm putting them in that category. The second category is people who are on temporary legal status. So people who are students who come as tourists. There's like a laundry list of different work visas, temporary visas that people can have. And of course, those people are here only for a limited period of time. Now, some of them may be able to apply to become lawful permanent residents, and we'll talk about the pathways that people have. But if they don't do that, at some point, they're going to have to leave the country. And then the third group, and probably the one that gets the most attention, of course, are people who are undocumented, people who don't currently have immigration status in the U.S. And that could be either because they entered the country without permission or because they came on a temporary status and now they've overstayed the period of permission that they stayed here. And notice that I use the term undocumented immigrant. I do want to acknowledge that sometimes you might hear other people use other terms, such as illegal immigrant. I encourage people to use the term undocumented immigrant because we believe as a human rights organization that nobody is illegal. And that's the reason that we use that term, and I think that's something that in the community is really important to highlight that folks react pretty negatively if you use the term illegal immigrant. So we talked about how people want to get this document, the green card. That's the pathway to be able to stay here. If you want to stay permanently in the United States, getting a green card is kind of the pathway to be able to become a United States citizen and to be able to stay here in the U.S. permanently with your family, to be able to work without restrictions. So how do people get green cards? So if you look at the statistics annually of how many people get green cards each year, about 2/3 of people get green cards through family petitions, through family members who have petitioned for them to be able to get that green card. And these are pretty close family relationships. So sometimes you might hear some rumors that like, oh, you know, your second cousin can petition for you. No, it's very close family relationships. We're talking about spouses, parents, children who are over 21 can petition for their parents, or siblings, although for some of those categories, there's extended wait lists that we're not going to cover today. So most people, and this is going to be really important because this is the category that we'll talk about in a minute that is most impacted by public charge, is that category, the big category of family visa petitions and people who get green cards through family members. In addition to that, we have people who get green cards through employment visas. And so you'll see that about 14% of people do get green cards through employment. I will flag that employment visas are fairly restricted. So we often get people coming to our office who are working in industries like, you know, agriculture or hospitality or restaurants. And they said, well, I've heard that, you know, there's visas through employment. Is that a possibility for me? And the reality is that most employment categories are restricted in such a way that they're not available for folks in those industries. They require either people who have very advanced levels of formal education, specialized occupations. I tell people, you know, if you're a good baseball player or basketball player, you might be able to qualify for some of those. But most of the folks that we're working with who are low income, or who have not had the opportunity to pursue higher levels of formal education are not going to be able to qualify for an employment visa. And then asylum and refugee status is the other big way that people get green cards. Now, quickly, for those of you that are not familiar with this process, asylum is something that you get when you're already present in the United States. And this is a process to ask the government to allow you to stay because you fear persecution in your home country. Refugee status is something similar, but something that happens before you come to the U.S. So you have already gone through the refugee resettlement program and have been able to come to the United States with refugee documents, and so you already have that status. And for both asylum and refugee status, once you're in the United States for a year with that status, you can then apply to become a green card holder, to become a lawful permanent resident. And so you can see that about 14% of people are in that category. I should mention, by the way, that the refugee program, as many of you know, the numbers set by the government, by the president each year, have been drastically reduced the last couple of years. So the number of people who are coming in through the refugee program is significantly lower than it was at the end of the Obama administration. So as you can see from the percentages, that's roughly like 90+% come through those three pathways. So it's sort of like the big three pathways for being able to obtain green card status. There are other ways that may apply to some people who have particular situations. So there's a program under the Violence Against Women Act for people who could have been applied for under the family process, but who've been victims of abuse. And in that situation, they may be able to petition, do something called a self-petition. There's also a program for people who are under 21 who've been abused, abandoned, or neglected. That's known as the Special Immigrant Juvenile Status Program. There's also visas like the U and the T visas that apply for victims of crime or human trafficking. And in each of those cases, they also can lead to lawful permanent residence. But again, that's a small percentage of the total number of visas. And so I want to emphasize, as I said before, that family visa category is the biggest category in terms of the number of people that can get green cards each year. So now, when we talk about this process, one of the key things about getting the green card that I think is important that we're going to talk about, it's going to be very relevant when we talk about public charge, is how people can get the green card. And so we talked about the ways that people may be eligible to apply to be able to qualify for a green card, right? But for people who are pursuing green cards particularly through the family visa process, this also applies to a lesser extent to the employment category, but particularly for folks who go through the family visa process, just the fact that you may be able to apply for a green card doesn't mean that you're going to be able to obtain it here in the United States. And the reason for that is there is a rule that says that if you enter the country without permission in the first place, then you cannot, with some minor exceptions that we're not going to get into here, you cannot get the green card here in the United States. You have to leave the country in order to be able to get the green card. And so let me give you an example of how that works. Let's say a couple comes into our office this morning, and they say, listen, a woman says to me, I'm a U.S. citizen. I'm married. My husband here, he's undocumented. And I understand that as a U.S. citizen, I can petition for him to get a green card. And I say, that's right. But I asked the gentleman, sir, how did you come to the United States? And he says, well, I came without permission, 10 years ago. I crossed the border. I never had a visa. I just crossed the border. So what I have to tell him is that yes, they can start the process to get a green card, but he's going to have to leave the country. He can't get the green card. He can't apply, do something that immigration lawyers know as adjustment of status. You cannot do an adjustment of status of somebody who came into the country without permission. There's some minor exceptions to that, having to do with people who applied before 2001, that we're getting fewer and fewer of those because that was a long time ago. And so most of the time, people are going to have to leave the country. And the other problem is that when people leave the country, if they've been here in the United States for more than a year without permission, as is the case for this gentleman, I also had to tell them that if you leave the country, you're then barred from returning to the United States for 10 years. It's something called the 10-year bar. And so that becomes a big barrier for a lot of people. Now, there's a way that you can ask for a waiver of that 10-year bar and ask the government to not have to have you wait, but it's an additional sort of barrier that people face. And so that's an important situation, because that applies to a significant number of people that we're dealing with, that they're going to have to, in order to get that green card that we talked about, they're going to have to leave the country and go apply for the green card in the consulate. So that's why I mentioned earlier that the Department of State becomes very relevant, because the rules that the Department of State is applying make a big difference. And they have been, until today actually, they have been different from the rules that USCIS was applying here in the US. Now, note that if I had asked that gentleman how they came into the country, and he had told me, well, I came on a student visa, and I overstayed. I dropped out of school and I started working, and my visa is now expired. He wouldn't have to leave the United States. He would be able to stay and try to complete the process here in the U.S. He wouldn't be subject to this rule that he has to leave. And so it's a big factor, because when people have to leave the country, it frankly puts them at greater risk, because now they're outside the U.S. and if they get denied, they may be stuck outside the United States for a long time. And so that's a reason why, when we'll talk about the public charge issue, why we, particularly those of us that work in the immigration law context, are very cautious when it comes to people who are going to have to navigate the system outside the U.S. Because when we tell people, okay, great, let's start the process and you're going to have to leave the country, it's a big leap of faith, frankly, because then they might run the risk of having something come up during their consular interview that might prevent them from coming to the U.S. So this is a really important obstacle that I hope you understand. And this was true before the public charge. I do want to emphasize, this is not something that's new. This has been in place for a long time. But the public charge adds an additional sort of layer of uncertainty, because it's yet another reason that a person may be denied their opportunity for a green card. And while that's a barrier for somebody who's already in the U.S., it has kind of harsher consequences, I would say, for somebody who has to leave the United States to be able to pursue that process. So that's the overview of the system. Now, so let me just give you, this is kind of the quick, kind of a graphic way, if it's easier for you to see it, of how people can do it, especially through the family visa process. So the key first question is, are you even eligible to apply, right? So this is like, do you have a family relationship? Because we get a lot of people in our office who come in and say, I'd like to apply for a green card, but there isn't anybody who can petition for them to be able to get a green card. So that's the first question. Second question is, do they have to wait a long time? There's wait lists. So if somebody comes into our office, for example, right now and says, I'm here, I'm a U.S. citizen, and I'd like to petition for my sister who lives in India. And I'll say, okay, yeah, you can start the process for them to get a green card. But right now, it's taking about 23 years for you to be able to bring your sister, for the visa to become available for them, right? So that's going to be a long barrier. Then the question is the person eligible to even adjust in the United States to get the green card here, right? And so sometimes the answer is yes, if they came on a visa and they can complete the process here. But oftentimes, if the person did not come a visa process. If they enter the country without permission, they're going to have to leave the country and do the processing at the consulate. And again, they may be subject to one of these bars that prevents them from returning. So that's a kind of a quick overview, and hopefully at the end, they get the green card, and we'll talk about where public charge fits into all of this. One final thing that I wanted to explain with regard to the overview of the process is this concept of oftentimes people saying like, well, I've heard that if somebody just files a document that says that they will sponsor you financially, that you can get a green card that way. And this is one of those situations where people have kind of conflated two different issues, because they're right. There is something called a sponsor for an immigration process. But this is sort of on top of family visa petitions. So first of all, you have to have a pathway to be able to get a green card. And for some of those pathways, like the family visa process, you have to have also a sponsor. And this is actually the old rules of public charge. The sponsor was, the idea was that you were gonna secure somebody who is gonna make themselves, commit themselves to financially support you so that you wouldn't become, quote unquote, a burden on society is the idea, right? And so they said they created this process where somebody had to file an affidavit of support, where the person is signing a document saying, I'm gonna financially support the person. Now, in most cases, the person who files the affidavit of support is the same person who's petitioning for the family member. So, you know, if I'm petitioning for my wife to get a green card, then I will also serve as the sponsor, committing myself as a U.S. citizen to financially support her. But in some situations, there's criteria to be able to qualify as a sponsor. And you have to be earning a sufficient income. Generally, the rule is 125% of the federal poverty guidelines. And so, so if I'm not making enough money, my situation is such that I can't meet that criteria, I may be able to get somebody else, another U.S. citizen or lawful permanent resident, to serve as a joint sponsor to help me in the application. But there's got to be the family relationship, right? I can't just find a financial sponsor if there is no family relationship to start with. So that is what this process looks like, and so that was basically sufficient before to overcome most of the time the issue of public charge. If you had a sufficient sponsor, most of the time that was enough. But as we'll see in a minute, those rules have changed, and that is no longer going to be sufficient. You still need this, right? You're still going to need this, but just because you have this, the sponsor, doesn't mean that you're actually going to be able to overcome the findings. So let's talk about public charge. All right, let's take a deep breath. All right, so what is this concept of public charge? So public charge has been in immigration statutes since like the 1880s. And it is part of what in immigration law is known as grounds of inadmissibility, which is a really boring and obnoxious term. But what it really means is basically they are the list of reasons that the Congress created to say, these are the reasons that we're going to prevent people from coming to the United States or from becoming permanent residents of the United States. So they are the grounds to bar people from coming. And there's a long list of reasons. So there's if you committed certain immigration violations, if you have certain criminal convictions, if you, of course, national security, terrorism, there's a long list of things that could disqualify you from being able to enter the United States. And public charge has been listed in that list for a long time. And so that part is not new. What's new is that public charge is kind of a vague concept. And frankly, for a long time, the real history of this was that it was kind of a way for people of color, primarily immigrants of color, to be barred from coming to the United States. It was very discretionary, and I think, frankly, we're kind of coming back full circle to what public charge is being used for. And so who does this apply to? So again, it applies to people who are applying for green cards, whether inside or outside the United States. So even though you might say, well, if this is about keeping people out of the country, how can it apply to people who are already here? And the reason for that is because, if they don't have permanent status, they still have to be subject to those same rules in order to be able to get the green card. So it does apply to people, and it applies to people who are trying to apply for green cards through family and employment situations. It also is going to apply technically, we won't really get into this too much, but it also technically applies to people who are applying for other types of visas. So if somebody, for example, came on a tourist visa and they're trying to extend their tourist visa or trying to extend another type of visa they already have, technically public charge also applies to them. But I think the focus of my conversation today and our discussion today will be on people who are trying to get the green card, because that's what most of the clients are trying to achieve that we're going to be serving, is to be able to stay here permanently. So that's going to be our focus. Importantly, who does it not apply to? So one of the key things that we want to talk about is that this issue of inadmissibility of these rules does not apply to people who are already U.S. citizens, okay? Although we'll talk about in a minute how it could indirectly impact them if they're trying to petition for somebody, okay? They're trying to serve as a sponsor. It might be an issue because it might affect them, even not directly. It might affect them in the sense that somebody else that they care about is not going to be able to come to the United States. So that public charge does not impact U.S. citizens. It does not impact people who are applying for green cards through some of the other pathways that we talked about, right? So if somebody is getting a green card or applying for a green card through asylum, through the refugee program. So if they came in as refugees and now they're applying for a green card, public charge does not impact them, okay? If they're getting green card through the VAWA process that I mentioned earlier, through U or T visas, or through special immigrant juvenile status, and there's a few other categories where public charge does not apply. So if those folks are navigating that system, they don't have to worry about public charge in that it's going to block their ability to get a green card, okay? Now, one of the questions that we've gotten is, well, what about people who already have green cards and are now considering applying for citizenship? Does that apply to them? Generally, the answer is no. So once you have a green card, you're generally not going to be subject again to the grounds of inadmissibility. There's one important exception. If you're a green card holder and you leave the United States for over 180 days, then by law, you again become subject to the grounds of inadmissibility. It's sort of like the government can now start rechecking you again and seeing if you should be allowed back in. And so this is one of the reasons that immigration attorneys advise strongly green card holders not to leave the country for longer than 180 days until at least they've talked to an immigration attorney, right? It doesn't automatically mean that you're going to lose your green card. It just means that you put yourself at greater risk, right? So I always give people that caveat, is that green card holders should be safe from this, except if they leave the country for 180 days. Frankly, even if they do leave for longer than 180 days, the chances that they're going to be, given trouble because of public charge are relatively low. But, particularly with this administration, I don't want to, predict or say something that is not going to play out. So people need to understand that there is a risk once people have left the United States for longer than 180 days. So that's who public charge applies to or not. And again, to try to make it a little bit more graphic, if people are applying through the family or employment, public charge applies when they're applying for the green card, right? If they're applying through some of the other programs, asylum, refugee, VAWA, U or T, does not apply. And once they have the green card, if they're applying for U.S. citizenship, then it does not apply. That's kind of the pathway for people to be able to get status. One of the important things is, I do want to remind folks, right? A lot of folks are kind of in this status and they don't really have a clear pathway. I think it's important for us to remember that, because I think this chart makes it seem like everybody's got a quick path to be able to get a green card. And unfortunately, we have a lot of people in the community who do not have that person who could do it. Or even if they do, they're ultimately going to be barred from being able to apply for it. So we have a lot of community members. For example, we have young children who are U.S. citizens, and people think like, well, if they have U.S. citizen children, they're somehow able to stay here. And no, they're not able to get to do it until they're 21 years of age. The children can't apply for the parents until they're 21. And even when they do turn 21, we have families who come to us and say, well, my child is now over 21. So they can petition for me, right? And I say, yes, but here's the problem. They can petition for you, but if you came to the country without permission, you have to leave the United States to get a green card. And there's no waiver in that situation where it's a child applying for a parent. And so in order to get the green card, you're going to have to wait outside the United States for 10 years, right? And so there's a lot of folks who are in this undocumented status who are not really going to have a pathway to green card status. And so it's important to keep that in mind, because when we talk about public charge, a lot of times part of the issue is going to be like, does this person even realistically in the short term have a pathway to be able to get green card status? And a lot of families, unfortunately, the answer is no. That's when we talk about comprehensive immigration reform. It's creating a pathway for people who currently don't have a pathway to be able to get a green card status. All right, so what have been the changes with regard to public charge? So as I mentioned, the concept has been there for a long time, right? So it's been in the law for a long time. But it's been, over the years, the interpretation has changed. And in the last few decades, the interpretation has been really narrowed so that it only impacted very few people. And since 1999, the clear rule had been that people, with respect to people who are receiving public assistance, the only thing that created a risk of public charge was if the person had been receiving cash assistance programs, right? Or if they had been placed in some sort of government-funded institutionalized care that was kind of long-term. And so this was very, most of the time people who are undocumented, who don't have status, weren't eligible for cash assistance programs. And so it was very few people who got impacted by public charge. And the only other issue was whether they could find somebody who signed the affidavit of support. And so most of the time, if somebody had somebody who could do the affidavit of support, then public charge was not an issue. And so it wasn't like a big, it was there, but it didn't impact very many people because it was very narrowly written or understood, I guess I should say. That was the interpretation. And so people, had to get the sponsor, but the kinds of assistance that could be considered were pretty narrow. So what happened was that starting 2018, the Trump administration started rolling out proposals where effectively they broadened the interpretation. So that same phrase, right, public charge, which was kind of like not really defined in the immigration statute, they said we're going to read the same phrase, but give it a whole different meaning, and it's much broader, and we're going to start considering lots of things. So the first thing was in January 2018, they changed the interpretation rules at the Department of State. And they could do this kind of more quickly because there's kind of lesser protections for people who are outside the United States. And so they changed the rules at the Department of State, and they said, we're just going to consider lots of things. And some of the things are similar to what the DHS rule. And they were also asking, they started asking a lot of places, they started asking questions about all kinds of public assistance that people may have received. And so it was pretty scary for a lot of us because it really put a lot of people who were having to go through the process at risk. I will say that it was pretty inconsistently done because it was the way that the Department of State was using these rules, it was very vague. And so different consulates were doing it very differently. And frankly, it's one of the concerns that we have about the new public charge rules because I think different offices may be interpreting differently. So that was what was happening in the Department of State. Got a little less attention, I think, than it was warranted. Then in August of last year, in 2019, after several proposals had been put out there, the Department of Homeland Security put out this new regulation, the one that we're kind of focusing on today. And that regulation is the one that impacts people who are going through the process here in the United States. Really important, remember, I want to emphasize this point. That rule applies to people who are going through a process here in the United States. It doesn't mean that it's the only rule that applies to people who are inside the United States because there are people who are going to have to go outside the United States, right? So they're going to have to go through the Department of State. So both of them, the Department of State and the DHS rules, are relevant to people who we might be working with. So that rule was published, the final rule. It was supposed to go into effect on October 15th of 2019. As many of you know, there were multiple legal challenges filed, including one by our state attorney general. And that led to a number of court decisions that blocked the implementation. They put it on hold, so it didn't go into effect on October 15th. And then the Supreme Court last month lifted those injunctions, and actually on Friday lifted the last injunction that was in place for the state of Illinois. And so now, as of this morning, this new rule is going into effect for any applications that are filed today going forward. So this doesn't apply to people who already were in the process. I do want to make clear. So if people already filed an application before today, they are subject to the old rule, but anything that gets filed from today and after is going to be subject to the new rules that we'll talk about today. So what does this new rule say? Well, the new rule says that now, and the key phrase, and the one that immigration lawyers will be trying to figure out for the next however long this is going to take. I will say, so actually, let me just go back and say one quick thing. So the Supreme Court allowed the rule to go into effect. The legal challenges are still actually ongoing. So what the Supreme Court said is like, listen, while these legal fights are going, you can start using this new rule. The lower federal courts had said, no, you got to keep the old rules until we figure out if this is legal or not. So the Supreme Court said you can go into effect. Now, the cases are still going on, and there's still appeals filed, okay? So there's a chance that in the future, there could be a ruling eventually that says that what DHS did is illegal. But it's likely that will only happen if the Supreme Court takes up the case. And in the meantime, we're going to have to live with this new rule until the Supreme Court rules, which frankly is going to be at least a year. And so, yes, there is a chance still, and you might hear that there's appeals still going on, and that's true. And we hope those appeals will be successful. But in the meantime, we're going to have to live with this rule for the next, I would say, at the very least, a year. And obviously, there's also a chance that if there's a new administration next year, that they will decide to change back the rule in a different way. So that's another possibility. So what does the new rule say? So the new rule says, okay, now we're going to have a totality of the circumstances test. And we're going to be looking at all these factors that are listed here. Age, income and assets, health, family status, education and skills. We're going to also consider affidavit of support. And then public benefits is actually included in the income and assets category. And so that's what we're going to be looking at. And we're just going to look at everything and make a decision as to whether the person's a public charge. Each officer will get to make a decision weighing these things. And so it's very vague. There's some things that are listed that say they're either positive or negative, or there's some that are heavily weighted positive and heavily weighted negative. And so just to give you kind of a quick example of what these are. So if your household income for the person who's going to be getting the green card is under 125% of the federal poverty line, that's a negative. If it's over 250% of the federal poverty line, that's a heavily positive category. So this is why a lot of people are calling it a wealth test, because it literally is that. I mean, it gives you kind of extra points if you make more money. Age is also a factor. So if you're a child under 18, or if you're older, over 61, that's a negative. And if you say, like, why is that? It's because, like, well, you can't work, or you're presumed not to work. And so, or you're like considered to be less employable somehow. That's literally what the rule says. And so that's considered a negative factor, because they think the whole idea is that they're trying to weigh what are the chances that you're going to, at any point in the future, require certain forms of public assistance, and we'll cover what those are. And it's really federally funded assistance. And so they consider those issues negative. There's also issues about education and skills. So they're going to consider whether what level of formal education you've received. Included in that, and this is kind of very scary to us, is a level of proficiency in English, which has never been an issue at the green card stage. So as many of you know, there is a language test when you apply for citizenship, when you apply to become a U.S. citizen. But that's after usually you've been a green card holder for several years. And so there's a chance to sort of have the opportunity to learn English during that period of time. This is actually adding now proficiency in English. And it's very vague, right? We don't know, are they going to do like a specific test? And if so, what is that going to look like? And if they're not going to use a specific test, then is it going to be just subject to the whims of a USCIS officer to decide, like, you know, your English is good, you know, you have a heavy accent, so I'm going to say you're not. And so it's very scary for a lot of us of how that's going to be playing out. There's also a health factor. And one of the things that it says is that if you've been diagnosed with a medical condition that is going to require extensive treatment, that could be a negative, in fact, a heavily negative weighted outcome. So it's actually, you know, a lot of us sort of operate in this idea post like ADA where those things would be kind of protected. In this rule, it's actually like explicitly kind of a negative factor that could preclude you from being able to get status in the U.S. Family status, what that means is effectively if you have a large family, that's considered a negative because you have more people to support. And then the affidavit of support is still a factor that they'll consider. Again, as we talked about, this commitment that somebody's going to have to be made. But now it's no longer sufficient, and they're also going to be kind of looking at it much more closely. And we know a little bit of what that happens from the way that the Department of State has interpreted. So, for example, one of the things that they have done more recently is that it used to be, for example, that, hey, if I just got somebody to do, let's say I don't have enough income to do the affidavit of support myself, but I get my cousin to do it, and my cousin happens to live in another state. It used to be that was not an issue, right? Like as long as they were a U.S. citizen, they could show they had the income and they made the commitment, that was enough. Now the Department of State is saying like, well, you know, this person's living in another state, so maybe they don't have that close of a relationship with you, and so we're going to question whether they are actually going to be able to support you. Now, that doesn't have anything to do with anything, right? But that's the kind of questions that they're raising now at the consulates, or they have been, and that now under the new rule, they can start looking kind of behind, questioning whether the person really is going to commit to doing it. And so that's really scary. And so I think the thing that I want to emphasize with this slide is this is what's scary about public charge. Like, it's not just the public assistance. We'll talk about in a minute about the public assistance. It's the fact that now people navigating the system are going to have to navigate all these potential issues. I mean, and literally, we're at our office now are going to have to start asking people about all these questions and not be sure. Like, I don't know exactly what's going to be an issue, right? Like, if the person has, you know, asthma, is that going to be a condition that requires, like, there's no guidance on what's going to be considered a problem, right? Again, English proficiency, I don't know what's going to be considered a problem. And so I think a lot of us are really scared about the fact that a lot of officers are going to be using this in a way that could be potentially very discriminatory and very vague and very hard to challenge because it's this totality of the circumstances, right? And so that's what's scaring a lot of people, and rightly so, in terms of what this could mean for a lot of people that we're working with. So a lot of the attention, though, of course, has focused on the issue of receipt of public assistance, and so of public benefits. And so I do want to talk a little about that to highlight in some ways how that part is actually not as bad as most of us thought, or not as scary, except in what we'll talk about in the chilling effect. Because the rule, the ultimate rule, there were some proposals before that had different factors and that were broader. But the final rule that goes into effect today only takes into account, so first of all, it only takes into account things that were that people receive after today, except for the very first one, actually, the cash assistance piece, because that comes from before. So that will continue to be taken into account, and if people are receiving cash assistance before today, then that will continue to be a factor. But so first of all, it only counts things that the person themselves that is applying for assistance that's applying for the green card received. So it does not take into account public benefits that are received by other people in their household, right? So, for example, if I am an undocumented parent of U.S. citizen children, the fact that my U.S. citizen children are receiving any kind of public assistance does not count under the DHS rule. It's not going to count against you for the undocumented parent's application under the DHS rule. Okay. Other things so the things that do count against you is if you, again, the person who's applying for the green card, have received, cash assistance, which again is the old rule, Medicaid, except for it has some exceptions that are really important, emergency services, any receipt of Medicaid services by children under 21, pregnant women, and services immediately, and it says 60 days after giving birth. The SNAP program, also known as the food stamp program, federal public housing, including Section 8 vouchers and project-based rental assistance. So it's only, besides the cash assistance piece, it's only federally funded benefits. And the rule says that if you receive 12 months of benefits in a 36-month period, then it's a heavily negative factor against you. Okay, and actually, if you receive, so for example, if you were to receive, for example, SNAP and Section 8 during the same month, then that counts twice. That counts as like 2 months. Okay. Now, I know all of you are like, okay, well, I got to try to figure out this applies. Keep in mind, okay, because I remind you, federally funded benefits, only these benefits, and only for the person who's applying for the green card. Well, guess what? Most people who are applying for a green card, virtually everybody who's applying for a green card is not eligible for any of those federal funded benefits. I mean, when the rule came out, we were trying to figure out, okay, who could possibly be needing to apply for a green card and still be eligible for those benefits. And the only group that we can come up with is people who got this form of protection called withholding of removal, which is kind of similar to asylum. They're technically eligible for those federally funded benefits, and then they could potentially, at some point in the future, they already have status. They have this work permit. They could then apply. They may be able to apply for a green card through a family member. So there's a few people who might be eligible for the federally funded benefits and be applying for a green card. But the vast majority of people are not actually eligible for those federally funded benefits. So the issue of benefits is actually not going to block most people. And a lot of you may be like, so why did they put it in there? Like, that doesn't make any sense. Why? Well, I think most of us think that the reason they put it in there is to scare people. Because the messaging was, if you accept some benefits, then you're going to be barred from getting a green card at some point in the future. And that's the message that's gotten out in the community. And so now people think that that's the case, even though the way the rule is set up, it's very, very few people are going to be impacted. Very, very few people. And so most of the time, I mean, again, and this is one of the hard parts for us as immigration attorneys and as advocates, is that I can't give you like a complete reassurance to tell you, like, look, this is not going to impact people at all. I wish I could say that. I wish I could tell you, you can go back to community and say to people, like, receipt of public benefits, totally fine. Because there are going to be some people for whom it could be a negative factor. Okay, and let me talk a little bit about that right now. It could be a negative factor for people who have to go outside the U.S. to get their green card. Now, the Department of State, because again, the Department of State had rules that were different. Now, on Friday, and this is how chaotic the situation is, on Friday, finally, the Department of State said, okay, we're gonna implement, as of Monday, the new rules at that DHS. So technically, as of today, the rules should be the same, both at the consulates as well as here. But I am still a little nervous. I mean, as people say, you know, I'll believe it when I see it. because we have had very inconsistent practices at the consulates. And so we do worry at this point. I'm still worried about people being asked about that when they have to leave the United States, because again, they could get stuck out there because the consulates have been applying this very inconsistently. And the other issue is that even though the rules say one thing, the problem with people who are going through the consulate process is that they don't have the same kind of protection. If somebody's denied a green card while they're here in the United States, we can fight that through the courts and try to get that overturned. But that's not possible for people who are outside the US. It's very difficult to challenge those decisions of the consulates. And so we're still very cautious in telling people that it's completely safe to accept benefits for people who are going through a consulate, who are about to go or who are expecting to have to go through a consular process. So we'll get more into that. But again, for most people under the rules, it shouldn't really affect them, okay? Because they're not going to be eligible for those federally funded benefits, okay? So besides the cash assistance piece, the other type of benefits, state, local, are not covered by the DHS rule or by the new Department of State rule that goes into effect today. And I know a lot of you might be like, wow. And exactly, because like the way the messaging has gone on this, it has made people really scared that any kind of benefit is going to count against them, right? Now, keep in mind, though, that's why I was saying in the beginning that it's kind of this complicated messaging, because on the one hand, that might be reassuring for some people, but on the other hand, when you see all the other issues, you might see that there's still a problem, right? Because some of the same reasons that people may be needing assistance is still going to impact them, right? So people may not be denied because they received, a public assistance, but they might still get denied because their income is low, which is why they were seeking assistance in the first place, right? Or they may not get denied because they applied for some medical program that's helping them get treated, but they might get denied because they have that medical problem that is going to be a factor that is going to count against them, right? So that's the challenge that I think we're going to have to deal with, is that I think our messaging for the community can't just be like everything's fine, because it's not. I mean, unfortunately. That's why a lot of us, as Oksana mentioned, this is like a really depressing conversation to have, is because now those of us that are helping people navigate the immigration system are having to have these conversations and explain to people that things are going to be held against them that seem profoundly unfair. But that's the reality of how things are the new rule is supposed to go into effect. So again, I do want to emphasize our caution around how people are being treated in the outside consulates. And let me just tell you a story of to emphasize how concerning has been how the consulates have been applying this rule, by giving you an example of a family that we're helping in our office right now. So one of our clients is a woman who's a U.S. citizen here, who's living in the Seattle area, and has young children. In fact, gave birth about a year ago to a child who was born premature, and because the child required a lot of a lot of care, she had to spend time taking care of him, and had to stay out of work, and had to rely on public assistance. Right now, the child's a U.S. citizen, the mother's a U.S. citizen, so you think like, well, public charge shouldn't be an issue, right? Well, the challenge is that she was also at the same time petitioning for her husband to come to the United States. She was filing a petition. Her husband's abroad, and was trying to come to the United States. And during the process, because she was serving as the sponsor, the consulate counted the fact that she was getting public assistance as a negative, right? Because saying like, well, you can't support your husband because you're relying on public assistance. And so she had to get a joint sponsor to help them. And then this is where they were questioning, joint sponsor was somewhere in another state. And so as of today, she hasn't been reunified with her husband, because the government continues to allege that because she got public assistance for her and for her child, that should somehow count against the couple And she's kind of making a very sort of compelling and rational argument, which is that if my husband were here, we wouldn't need to be in public assistance, right? Like, he can move here, he can help, he can work, he can take care of the child, or I can, and we can go back to work. And all of us are like, of course, that makes total sense. But that's not the way the government is interpreting the rule. That's not how they were interpreting at the consulate. And so that just gives you a quick snapshot of why we worry about the situations that are happening in the consulate, because that kind of, what in some ways seems like an irrational way to interpret the rule is actually impacting families and literally keeping families apart at this very moment. And so, again, I wish I could give you sort of a reassuring answer, but unfortunately, the way the consulates have been interpreting things is going to make it difficult. And again, the issue particularly will be for people who are trying to petition for other family members, right? So if I am trying to sponsor somebody else, my financial situation is going to be a factor, even if I'm a U.S. citizen. So that's why I was saying that public charge impacts U.S. citizens indirectly. It doesn't mean that I get blocked from the country, but it might mean that I can't bring my husband or my spouse over, okay? So the bottom line on this is, public charge is likely to make it more difficult for people to come to get green cards, people who are already in the United States or people who are outside the United States. There's been different estimates. I've seen things. One estimate said that it's going to be a drop of about 30%. We've seen estimates up to like 2/3 in terms of the number of green cards that are going to be issued. And if you read there's an article in the New York Times just this morning about how it's already dropped 11%, right before the public charge rule went into effect. And so this is going to have really bad outcome for people, because either people who are already here in the United States who might have been able to get green cards and been able to be protected from potentially being subject to deportation are not going to be able to do that. Or, as in the case of the family that I mentioned earlier, people who are wanting to reunify as a family who are currently outside the United States are not going to be able to do that because of this. And again, such vague factors that it leaves it very unclear on how these rules are going to be applied. And so for us, the messaging with regard to benefits, which I know is one of the things that most people have been focused on, is the key message that we're trying to send to the community when we do these workshops to directly impact the community members. The message that we've been trying to send and that I would encourage you to send is like, don't drop benefits just because you've heard these rumors, right? Like the benefits that are impacted are generally are not available to most people, right? The federally funded benefits are the ones that are applied in that rule, right? So don't just drop benefits until you've talked to somebody about your own situation. Because what happens when people do come to us, so, and one of the resources that we're going to, give you is ours, and our organization, I realize, I know my staff is a little nervous about my giving that message, because I know that means that we're going to get a lot more calls. But we want people, because what we'll do is we'll try to screen people, basically, and try to figure out, okay, what are your current options? Right? Because for a lot of people, again, there isn't a clear option right now, right? If they're undocumented and they don't have somebody who's going to sponsor them right away, then there isn't, in my sense, there isn't any real risk, right? I mean, I've had conversations where people say, well, what if like down the road I want to apply for a green card? Could that affect me? And I say, hypothetically, if you ask me the question that way, yeah, hypothetically, yes, that's a possibility. But it's such a remote possibility, and if this assistance is important to the health of your family, then you need to weigh that, right? And of course, ultimately it's the person's decision of what they need to do, and we will respect that choice. But I just want them to make an informed decision as to whether they're gonna draw benefits, because I think when most people hear that it's very unlikely to affect them in the short term, and that it's not necessarily going to block them even down the line, then a lot of people may opt for maintaining those benefits. But again, I also can't say that it's completely safe. Because if somebody comes to me and says, I'm receiving benefits and I'm actually trying to sponsor my child or my spouse, what's your advice? Is this gonna negatively impact me? And I will have to say, yes, it could impact your ability to be able to petition for that family member, right? And so we unfortunately don't have kind of a clear-cut message. In addition, if somebody comes to me and says, well, I am married to a U.S. citizen, and we're actually thinking of going through this consular processing system process to be able to get a green card. But I'm currently on public assistance. Like, what do you think? Is that going to be a factor? And my answer will be, listen, the public assistance that you might be getting right now is not on the list because it's not a federally funded benefit. So I think the risk of that is low, but I can't guarantee anything with these consulates until we see kind of a more clear pattern of how they've been interpreting this rule, because the way that we've seen it interpreted in the past has been pretty broad. And so, again, we may not have a clear answer for people right now, and we probably won't until we see for months exactly how they're interpreting these rules. But the best we can do at this point is to give people, the best information we have and allow them to make an informed decision. What I am concerned about is that people, and I know because I've heard from a lot of social service providers, that a lot of community members are just, opting to play it safe. And I know one of the questions that people have also raised is like, hey, well, you guys, the immigration attorneys, you're the ones that are kind of scaring people off. And I want to acknowledge that. I mean, attorneys, we tend to be kind of risk averse. And when clients come and tell us like, well, what's the safest course of action? A lot of attorneys are going to say, well, the safest course of action is not to pursue benefits, right? Because they're only thinking of like the immigration process, right? And that's their role, right? I mean, they're advising people as to what that could impact them. And so they're thinking, well, just to play it safe, the safest course of action is this, right? I think, and trust me, I'm encouraging folks to think more broadly of the person's circumstances and to give people as much of advice as to what the potential risks are versus the benefits. But you understand why a lot of folks on the immigration attorney side are really worried about these things and how they might potentially impact people. So again, to recap, talking about what the messaging should be for the community. So again, if somebody is petitioning, even if you're a U.S. citizen or a permanent resident, if you are trying to sponsor for a family member to come to the United States, then the fact that you're receiving public assistance or public benefits could impact your ability to do that. That's just the reality. And frankly, it's not even it's not only the fact that you're receiving public benefits, it's the fact that probably indicates that your income is low, and that's in itself is going to make it more difficult, okay? That is a challenge. But I think, so in that situation, I think it is important for you to talk to an immigration attorney. If you're trying to petition for somebody, we absolutely think that you should be talking to somebody, an attorney or an accredited representative who's somebody who's authorized to practice immigration law and works for a nonprofit agency, to understand what your situation is and whether it might make sense in your situation to consider dropping out of a program so that it doesn't affect your ability to be able to apply for somebody. If you're a green card holder, what's the messaging? So it is not a problem to receive public benefits for which you're eligible. Note that I added that for which you're eligible. Because we have seen it be a problem if people provide false information in a application for public assistance. And unfortunately, we have seen some situations where people have been prosecuted for quote-unquote welfare fraud, and that can be a reason that somebody could actually be deported. And so we do always encourage people to be very careful about that. The other thing that we have seen people, and I do want to flag this, we have also seen situations where people have been questioned at the naturalization stage if they've left the country and they were receiving public assistance during the time that they were outside the United States, that the immigration may actually look at whether they informed the benefits agency that they were outside the United States because they weren't perhaps supposed to be getting those benefits while the person was outside the United States. So if you're a green card holder, if you're eligible, you can receive those benefits, but we do warn people that if they're outside the country to make sure that they inform the agency about that because that could be an issue. And then, again, not leave the country for over 180 days without at least talking to an immigration attorney to make sure that that's not going to be an issue when they came back. So that's the message for green card holders. This what if you're talking to somebody who's undocumented or who only has temporary status and is concerned about how this is going to affect them? So if you are applying for a green card through one of the programs that we talked about earlier, if you're on refugee status, if you're obtained asylum and are now going to apply through those programs, if you're doing it through the VAWA program, through U or T visas, public charge is not an issue for you. So that's not going to impact those community members that are going through those programs. But again, that's a narrower group of people. If you are if you're applying for a green card through a family member, which again is about 2/3 of people who would apply for a green card, then the receipt of public benefits should not affect your ability to get a green card through the family, inside the United States, because the public benefits that are an issue are ones that people are not eligible for, right? So I think we can tell people that they should be safe in that regard. Now, there is more risk if you're applying outside the United States. And again, who has to apply outside the United States? It's people who came into the country without permission initially, okay? So folks who have been told or who understand that they have to leave the country to be able to get the green card, they're going to be at greater risk. Again, technically, as of today, the rules should be the same, right? And so part of me wants to say it should be the same as people in the U.S., but that's the problem, is it should be versus how the consulates are going to interpret these rules is something different. The key message is that if anybody is filing a petition, if somebody is like in the process, if they're thinking about it, if they've already started the process, or they're going to sponsor a family member, then it's particularly important that they talk to an immigration attorney or an accredited representative about their individual situation to figure out what the risks are in their individual case before making a decision. We don't want people to just drop benefits because they're like, well, I heard if you're going to start a process, you shouldn't, or there's a risk. And so, no, talk to somebody who knows about this, because the person may not be even eligible. They might think they're eligible, but they're not actually eligible to pursue petition. So why are you dropping of assistance that's important to you if that's not going to help you, because it doesn't matter, you can't apply right now. And so if you don't have prospects, if you don't know that you can pursue a petition, or you know that you've talked to somebody and they've told you you can't pursue anything, then in our opinion, there's no reason for you to drop or to forego assistance for which you're eligible, right? If you're in doubt, then talk to somebody, an immigration attorney, to figure out if there is a pathway for you right now. And again, I know there's going to be some folks who say, well, this could affect them in the future. And that is something that I think individual community members are going to have to weigh, that yes, I mean, at some point in the future, the rules could change again. There could be a reason why this could affect them. But in my opinion, that's not a reason. This hypothetical possibility down the road is not a reason for them to make a decision to drop public assistance or to forego something that they're eligible for. So again, I wish this was all like one little point where I could tell you you tell everybody is safe, or here's the clear rules for everybody. But I hope in the last few minutes you've understood why the complexity, right? Why the rules are different for different people, and why we have to be careful. And the best we can do is to provide people with the best information we have right now, even though we know that this kind of like mixed, kind of unclear messaging and uncertainty is not going to be super reassuring for a lot of community members that we work with. I wish it were different, and I think, frankly, in some ways, that's what the administration is trying to do, is to create this uncertainty that's going to lead a lot of people to forego things. But that's the reality that we have to operate in. And again, I think one of the key things is that that's something that we all have to work on, continuing to learn about how these rules are going to be applied, because I think we'll learn more as we see how this is actually playing out at the different agencies. Now, a couple of other issues that people have brought up. So one of the questions, and before I get to these points, so one of the things that people have asked me is like, well, how is the government going to know about these benefits? Like, are they checking some sort of databases? The main way that the government finds out about these things is asking. The applicants have to disclose this information, right? So most of the time in these forms, there's these very long new forms that they're going to have to fill out where they're asking all kinds of information that people have to disclose. And of course, as immigration attorneys, we always have to advise people that they have to disclose everything that they asked, because immigration does have a lot of ways of finding out information about people, and so we never want people to say something that's not true, because that will actually really make it much more difficult, if not impossible, for them to be able to qualify for a green card in the future. So really important for them to disclose. A couple of other issues that we're dealing with is that the forms, for example, not only require people to report whether they've received assistance, they also require them to disclose if they've applied for assistance. And so we're a little worried about how this is going to play out for people who, for example, might have applied for health coverage, and they might have been like screened for Medicaid. Are they going to have to disclose that, right? Because they might have applied, they might have been denied because they were not eligible because of their immigration status, but is that somehow going to have to be like disclosed in that application? So we don't know. So we're trying to figure this out, literally also trying to figure out, okay, what are we going to say in this form when they ask us that? Because it's not always clear if the person applied maybe because they didn't know they were eligible, then they were denied because they said you don't have the immigration status to qualify for this program, but we may have to disclose that, and if so, is that going to be like a negative factor that they're going to consider, the fact that the person sort of inadvertently applied for a benefit? And so that's one issue. And then the other issue is that some of you may have heard, and I know in some of the questions that you submitted, some people have said, well, I heard that there's this other issue of like them taking green cards away from people who receive public assistance. And so what that is, for those of you that may not have heard about this, is that there is a separate proposal that's been that's been talked about, and the administration has acknowledged that they're considering, which is there's another aspect of public charge that applies for people who already have green cards and who receive certain types of public assistance within the first 5 years of being in the U.S., where, yes, in theory, they could be charged as deportable and being actually put in deportation proceedings and have their green cards taken away, okay? That provision does exist in the immigration law, and frankly, it has almost never been used, certainly in the last like 20, 25 years. And so it exists in there, and again, it could be that they will propose something to broaden that, but that has not even been formally there's not even been a proposal published in the Federal Register yet. So if that were to happen, that's still pretty far away from happening. So if you hear people in the community asking about that because they've heard and there have been news reports about it, yes, it is true that there has been some discussion of that, but that has not gone into effect yet. Again, I think there's going to be some populations who I think I'm particularly concerned about with regard to this. The health factor is one that I'm really concerned about, because a lot of people have very sympathetic situations where they have, a lot of times people say to us, well, we're trying to get status for a family member because they're really ill, and getting green card status is the one thing that will qualify them for the federal benefit, for a benefit that will actually help take care of their medical needs. Well, with this, it's actually the opposite, right? Like having that medical issue is actually going to block you from being able to get a green card. So I'm really concerned this is going to have a very harsh and disproportionate impact on people with health conditions. And again, I wish I could tell you like exactly what is going to be disqualifying, how harshly they're going to use it. I mean, because the way it's written, it could be fairly broadly read, but we just don't know exactly how they're going to apply it. But it's something that gives me a lot of pause. Again, the income factor clearly disproportionately and directly impacts low-income families, and so that's really concerning. And so those are the things that are playing. The other thing that's these are the two sort of some of the negative factors. The other one is that one of the negative factors is if the person has not been employed or a full-time student. And while there is an exception for primary caretaker of family members, I'm just worried about sort of the disproportionate impact that this is going to have on a lot of families who may have had kind of temporary employment or kind of irregular employment that they may not be able to substantiate. People who are day laborers, for example, who may not have all the documentation to be able to demonstrate that they were employed kind of consistently. I see a lot of problems with that, and again, we'll see how this gets played out in the coming months. So. I know this is all depressing, so I feel like everyone needs to take a deeper breath. The good news, if there is any in all of this, is that there's a lot of people working on this issue, and a lot of people are trying to sort of mitigate the harm of this. And I appreciate that, I live in a city and a state that is helping make these resources possible, and that there are a great community that is really pushing back on all of this. So I wanted to leave on this slide, and of course all of these are in the PowerPoint, so I don't feel like I need to go through every detail. So first of all, there's sort of broader immigration legal resources for folks who want information about where people can get assistance. There's a national directory, even if folks are dealing with people in other states who need assistance, run by the Immigration Advocates Network. The Executive Office for Immigration Review runs a list of all the organizations, all the nonprofits that are recognized and can provide legal assistance, including here in Washington. For folks who are looking to refer to a private immigration attorney, the American Immigration Lawyers Association has a referral service. That's alalawyer.com. And then I always refer, here in Washington, we have a great resource at the WashingtonLawHelp.org website. And then specifically with public charge, there's a great coalition at the national level that has a chapter here or an affiliate here, the Protecting Immigrant Families Coalition. And they have a lot of resources that I encourage you to visit and check out. There's also schoolhouseconnection.org has some resources focused on education to answer questions that I would also invite you to check out. So if when I mentioned to people like, well, you can send people to contact somebody for assistance. So I want to provide the direct contact information for our office. And so for folks here in Seattle, our main numbers are listed there, the 206-587-4009. We ask people just to be patient. I mean, we're not going to be able to, we don't do consultations the moment they call in. Unfortunately, these issues are way too complicated. We need to get an in-depth conversation with people, so they're going to be scheduled for an intake at some point. And so we do ask people to understand that our demand is high, and we have to kind of prioritize people who have the most urgent issues, like they're facing an imminent deportation or a deadline. And so that's our contact information. You have the information for our Eastern Washington offices in case somebody's watching from other parts of the state. They're listed there as well. And on our website, when you open our website, on the resources tab at the top, you'll have a lot of information, and we're going to be providing updates. Because again, some of these things we'll be learning more as we see how the rules are implemented. So I'd encourage people to visit that regularly. And then finally here, I'm listing the websites again as we start the process of Q&A. And so we're going to, for those of you that are watching via the Facebook Live, if you're watching this actually live, we're also going to be taking questions through the chat function of the Facebook Live, and then we'll start taking questions here. and Oksana is going to help us with, so please wait until you have the mic if you have a question, because we want to make sure the people who are watching remotely can hear your question.
Please raise your hand so I can come to you.
All right, we got plenty of questions here, and then we'll come back to the folks on the screen. So if you do have questions on the chat, please type them in, and then Joaquin will read them for us. Yes.
Carlos Jimenez, Centro Cultural Mexicano, the city of Redmond. How do we go about having your agency? Right now, I know you're going to be pretty busy having a workshop on East King County. East King County has been a little segregated about these services, as we know, but we do have a great community, immigrant community, that are in this situation. We're going to try at the center to have this kind of conversation with the community at large, but it's going to be difficult if the message is getting distorted already. For what I heard, your agency and every agency that is working on this are really preoccupied about the message that is given out there. On the mom and pop stores, we hear in gatherings with family gatherings, hey, did you receive food stamps? So you do this. The message has been already distorted. So we are really concerned when it comes to the East King County that we do not have the kind of services that I'm going to say you guys have right here in Seattle and the whole South Side. We are actually the only Latino or Mexican-American agency that we are on East King County with a physical space. So how do we do it? How do we answer questions to our community? What do we do? Our hands are tied, totally tied.
Well, Carlos, I appreciate that. And listen, I wish I had like a simple answer to that, because I think it's going to take a lot of work. And frankly, some of the answers that people are, some of the questions that people are asking us, we don't have clear answers, and we may not have clear answers right away. So I do want to emphasize that in some ways, this is going to have to be an ongoing process. I mean, we're going to be doing some workshops here that the City of Seattle is helping facilitate, and I will definitely commit to working with you to making sure that there's resources in East King County, so we can talk after the program about trying to set that up. But I understand that, you know, some of the messaging is still going to be unclear. And I know that for some of the community members that we're going to be talking to, it's not going to feel completely reassuring, because even though they might be reassured about the public benefits piece, perhaps, they're still going to be worried about some of the other pieces that I'm going to have to tell them about, you know, that unfortunately may negatively impact them, right? Regardless of whether they take the public benefits or not. And so we do want to encourage people to have like good information about things like, you know, the fact that, you know, the benefits that are received by family members are not going to count against them, because that's the thing that I hear the most. I literally actually did a presentation in Bellevue last fall, and I literally had a community member come to me and say, the question that I had is whether I should drop my kids off of Apple Health for Kids, right, like the medical program, and I was just thinking, like, I mean, it's terrible that she's even asking me that question, right? I mean, how much work have many community members done to make sure that people are included in these programs, that there's advocacy so those programs are available? And here's the question that she was asking me. And unfortunately, my answer to her wasn't like a clear, like, completely safe, right? Because at the time we were dealing with the old rules at the consulates, right? And so we were still having to give this like mixed messaging of like, well, it could affect you in the future if you were to apply through the consulate. I think we have more knowledge now because the rules of the consulates are supposed to be aligned with the rules here. But again, as you heard me today, I still had this like uncertainty because I want to see that that's actually how they're applying them before I give that reassurance to the community. And so I think, unfortunately, over the next few months, we're just going to have to like continue this community education effort because, as you said, the messaging has gotten out there that is you know, this perception that is not helpful, and it's not going to be one thing that's going to help balance that. I think it's going to have to be a continuing, all of us, everybody here, spreading the message about the reality and the resources that do exist, and having people have individual conversations, frankly, because I think at the end of the day, you're going to have those individual assessments so that people feel reassured that the messaging for their family, you know, what their situation is for the family. Because again, unfortunately, it's not a everything's fine message. I wish I could give that, but I think that would be unfair because the reality is that these rules are going to impact a lot of people in a negative way.
I just
Yeah.
also want to add a little bit. I know it doesn't address your concern about having resources outside of the city of Seattle, but the city of Seattle is organizing. We have 10 workshops for community members scheduled already between today and March 19th. So we will have workshops available pretty much twice a week between now and end of March. And we will publish that schedule on our website. And that's again, seattle.gov/OIRA. And I know, those resources are needed outside of the city, but if we're talking about King County, it's hopefully within an easy driving distance. And all of those workshops will be offered either on the weekends or in the evening. So please check our website, and if you have community members who could drive, many of them will be offered in other languages, in Spanish, in Chinese, in Ukrainian, and so those community partners are working hard to accommodate language needs as well. Okay, we have another question here.
Hi. The organization I'm with provides early intervention services to kids, so 0 to 3, and we're working really hard with our messaging. We're trying to get the message out that the majority of the kids we serve are U.S. born, and then we bill insurance, and then we also receive ESIT funding, so some state funding as well. We have definitely seen a drop-off, I think, because we share information with the state and with the school districts. There's just a lot of fear around that, even if we are reassuring families that their kiddos are eligible. The question I have is, we have had a few families who are here on employment visas which has sort of in the past year, we haven't had as many questions around this. And I guess these families are, in my mind, probably not subject to this, even if their children are not U.S. born. But we are hearing that from some families that are here on H-1Bs, L visas. And can you speak a little to that around if their children are accessing services, if you know of anything around that?
Yeah, and I will first acknowledge that, employment visas are not my forte because, our organization doesn't help anybody. The employment visas are mostly handled through the businesses, and so they kind of hire their private immigration attorneys. They're kind of automatically not eligible for our services. But what I will tell you is that public charge does apply to people in most of the employment visa categories, and so it is an issue that they have to consider. It tends to be such that because of the way the program is structured, where you're sort of being brought in for a particular job that generally is like higher paying, it tends to be less of an issue in terms of like the risk. But I think it is. But again, we don't know, right? Because like it could be considered now. The program that you're mentioning, is not federally funded. It's not one of the federally funded. So it shouldn't apply. It shouldn't impact them in terms of getting this. And so I would be comfortable sort of reassuring and saying like, these are not programs that are in the rule, right? But if somebody's doing, consular processing, right? If they're doing and a lot of times with the employment context, people do have to leave to get their stuff done abroad. I'm still a little bit nervous. I could see a lot of immigration attorneys being like, yeah, can you hold off if I'm in the middle of a process? Can you not apply for these things, especially if they're means-tested benefits, right? Like that's kind of like one of the things. If they're not, then that's helpful because then you can say, well, this doesn't have anything to do with limited income. So the fact that it's not a means-tested benefit is actually like helpful in that regard because it's not sort of like an indication that the person is of limited income or was considered low income. So in that sense, that might help their case. And I do think that it's reassuring, but the public charge is a consideration for employment visas. It just tends to be less of an issue because the way the program is structured, most of the time when people are coming through an employment visa, they're more likely to not to have like positive factors, I guess, like the 250% of the federal poverty line, those kind of things. All right, Oksana, I'm going to rely on you to tell me who I go to next. Yes?
Okay, yeah, I'm Gurmai from Eritrean Association. So you said Medicaid as a federal benefit is going to be for specific people, and for those who are out of the list, what insurance coverage or for medical bill can we have from our state and our local governments? And the second question is, if someone is rejected to be eligible for green card due to the lists which is provided today, what's going to be the result, or what is going to be happen for him? Is he going to be deported, or is he going to have another option? If there is like a deportation option is only, how it is going to be impacted for the United States government economy? Either is it going to be manageable for states, local governments, and the whole federal government? Thank you.
Yeah, thank you. Those are two good questions. So let me tackle the second one first. And because it's actually something that I didn't say, didn't get into, but so when people apply, sorry, I'm having a little problems with the mic here. When people apply for, is it the mic? Can I borrow that one real quick? Sorry, let me just switch to this one real quick. Just because I'm having trouble with this one. Okay, there you go. So the answer to the question about what happens if somebody gets denied their green card. So if they apply for a green card here in the U.S., right? They file that application and they get denied. There's very high risk at that point if the person doesn't currently have status, right? Which is most situations what happens, that they're going to be placed in deportation proceedings. And so this is why where you know they have a chance to like then renew their application before the immigration judge, and they get maybe a second chance, but it becomes very risky, right? And so that's one of the issues that what I was telling you, that for us as immigration attorneys, it's going to become a big question of, do I put people out there, right? If somebody comes into our office and says, you know, I want to apply for a green card, I'm eligible to apply here, do I, you know, should I go forward with this? Because, you know, it's putting yourself out there, and it's starting a process that could end up leading to the person being placed in deportation proceedings. So it's going to be a question that I think we're going to have, and a lot of the legal service providers are going to have with clients of, do you want to do that? And right now, there's a lot of uncertainty because, as I mentioned earlier, I don't know how you know, strictly USCIS is gonna look at those rules. And so I suspect that we're going to be very cautious in the beginning in putting people out there, and that's what the government frankly wants. They want to reduce the number of people who get green cards, and I think this is going to have that impact because people are going to be cautious about proceeding, at least until we have a little bit more certainty of like how the rules are going to be implemented. If your question is about somebody who's applying abroad, then it's even more complicated because the person's outside the country. If they get denied, then there's no deportation. The person just stays outside, right? They can't come in. And there's ways that you can kind of like ask the consulate to reconsider, but there isn't the same sort of process that you can challenge some of the decisions as we would if for somebody who's in the U.S. And so that is a big issue, what happens when people get denied. And when people end up being in the U.S., and I think part of the question that you asked is about the sort of like the impact that that's going to have. It's a terrible negative impact, right? Because the person who might have otherwise been able to get a green card might have then been able to get better employment opportunities because now they're authorized to work, right? They have like greater access to work opportunities. They're going to now have less because they're now maybe remaining without status, with expired status, and it's going to be worse for everybody. So I just, as you can imagine, I'm totally opposed to this proposal because it has this negative impact. I think your first question was about people who are perhaps receiving medical assistance through non-federal programs, as I understood your question. And again, I think that for most people, so those state-funded programs, state or local funded programs, or say like charity care at a hospital, right? Like those kind of programs, they're not covered by the DHS rule, right? So technically, they should not affect you, right? They should not affect somebody applying for a green card in the U.S. And technically, as of today, they should not affect people applying at the consulates. But again, people applying the consulates, I'm a little bit cautious, right? I don't feel comfortable yet telling you that it's completely safe for somebody who's going to the consulate that they receive that benefit. I want to see how this is going to be implemented at the consulates. But I think that the risk is lower now that we have this new rule from the Department of State that they announced that they're implementing as of today. And so I certainly would tell people who are in need of medical assistance that they should continue to pursue those programs until or unless they've talked to somebody, an immigration attorney, who's told them this is going to somehow negatively affect you. Okay, so I would say don't forego those benefits until you've had a conversation with somebody and they have actually told you, like, this is going to negatively impact you. Because for most people, it's not going to be a negative factor. However, the benefits, right? However, if that person's getting a medical treatment because of some health condition, it might be the health condition that's a problem, you know, and that's the really troubling thing about this whole proposal is that there's still ways that might negatively impact, just a different way than we have been thinking about before.
Okay, I saw 3 hands up here and then one in that on that side of the room.
My name is Ana Peralta, and I have a question regarding the waiver. So when I personally applied for my family, we had to include what is considered extreme hardship. For our family at the time, it was medical, financial, just having the spouse leave and probably not being able to pay your mortgage, things like that. Are they going to take that into account when they're doing like the totality of circumstances? Like say, oh, you have a waiver and it says here this and that and that. Is that going to be bad for you, or how is that going to play out? Because it kind of contradicts itself a lot.
Yeah, Anna, thank you so much for that question. And just to make sure that people understand what Anna's question is about is, when I mentioned about how people have to, when they leave the country, they're subject to this 10-year bar that prevents them from returning, but that in some situations you can ask for a waiver so that you don't have to wait 10 years, you can come back earlier. And as she described, one of the requirements in trying to apply for that waiver is to show extreme hardship, that your family is going to be really negatively impacted if this person, your spouse, your family member has to be stuck outside the U.S. for 10 years, right? So part of what you try to show, and sometimes in those cases, is, look, we're going to be financially, going through financial difficulties if that happens. And unfortunately, the answer is like, yes, that certainly they can take into account the information that you include in that waiver as a part of the public charge consideration. And so I think that's another way that you're going to have to like try to figure out how do you show hardship in a way that's not going to make it actually more difficult, because you could show hardship in some ways in saying like, well, I have these difficulties, but if it's any of the things that are in the considered here, they may make it more difficult. I think most situations will be able to work around those, but to answer the question that you had about can they consider that, yes. It's a totality of the circumstances. Anything that you include in an immigration application that raises concerns is something that they're going to take into account. For example, one of the questions that it asks is if you've ever asked for a fee waiver in an immigration application. So some folks sought a fee waiver at an earlier stage for something. You're going to have to disclose that information now that wasn't being considered before. So lots of stuff is going to be looked into. I think we will be able to work on some issues to make sure that it doesn't impact, but that is something that I think immigration attorneys are not going to have to weigh more closely when we're putting together applications for people to reunify families. Okay.
For the financial factor, are they going to consider the family income or only the applicant? I know the benefit side, it's only the applicant, not the family. But if the family petition for undocumented person, is the income going to be only the applicant, or are they going to be calculating the whole family? My second question also is health factor. Is it all self-reported, or do they have a list of health issue that you're going to be choosing from?
Yeah, thank you. So let me take the second one first. The issue with people who are applying for green cards is that for folks who are going through the family visa process, you have to have a medical exam. So whether you're applying here in the U.S. or you're applying in the consulates, you have to have a medical exam that is done by actually one of the sort of authorized doctors that USCIS approves of. So you can't just go to any doctor. And so that's when they're going to find out, because the doctor is going to conduct a health evaluation and they're going to assess any kind of health condition that you have. And obviously, they're going to ask you questions about health issues that you've had in the past. So I think it's mostly going to come from that they have, that they identify any of the health conditions that you have. With regard to your first question about income, unfortunately, I think people are going to have to assess both in some sense. I mean, mostly they're going to be focusing on household income, but what we've seen. So remember that you're going to have like this household income situation where they're going to use that as the measure. But if you're, for example, the sponsor, you're going to have to perhaps demonstrate your own income level to be able to serve as a sponsor in those situations. So it's kind of complicated how they're going to count the rules. It depends on the situations, but generally household income is how they're looking at that, at the 125% and the 250% rule. But there's going to be factors where the individual's situation is going to be very relevant. For example, on the employment side, like you have to show that you yourself as the intending immigrant are employable. Or have a history of employment, or can demonstrate why you haven't been working, whether it's because you've been a full-time student or because you've been a primary caretaker. So it's not just that like, oh, my family has a lot of money. They're still going to be looking at your individual situation as the intending immigrant in assessing this issue. So both of them apply to some extent.
Okay, we'll just take 2 more questions from here. I know we have more questions than time, and then we'll switch to some of the questions that came in through chat.
My name is Laura Yanez. I want to be quick. So my question is, what about the students that are applying for financial aid? Would that be considered a public charge?
Great. So for folks who are applying for educational assistance, frankly, of any kind, right? Like none of those are in the DHS public charge rule. So no scholarship, no federal financial aid, no state-based financial aid are in the rule. So it should not impact them because of that receipt of public assistance. Now, again, sometimes the public assistance may be based on the fact that you have limited income, right? So it doesn't mean that those students are going to be fine. The fact that they applied for assistance is not the problem. The problem is that they might be low income, and that will be a problem, right? And so I think this is one of those situations where we definitely don't want to discourage people from applying for those benefits. Keep in mind that most of the people who are applying for a green card are not going to be eligible for federally funded financial aid, right? Because if they're undocumented, even if they have DACA, they're not eligible for federally funded financial aid. But if they're applying for WASFA, for example, through the WASFA program here in the state level, I would not discourage people from applying for those programs. I think that again, if the folks had to go through a consular processing, could they potentially ask about that? It's possible. I think there's, if they're intending to do that in the short term, I would ask them to talk to an immigration attorney to weigh that more closely. But for a lot of folks who are here who don't have any pathway right now, I think the risk is so minimal that I would definitely, and it's not listed in any of the rules, I would feel comfortable assuring them that they should move forward with that. In fact, because I think you also have to consider the flip side, which is they take into account education, right? So if you've gone to school and if you've pursued higher levels of formal education, that's going to be helpful to you. And so remember, even if some of these public assistance things were to count against you, it's not determinative. It doesn't mean that like you're definitely barred. They're going to have to consider the other positive factors. And so pursuing higher education is actually going to help you in that it's going to be a positive factor on the totality of circumstances. So for those folks, I would say, yes, go forward with education assistance.
Okay, one more last question here.
Good morning. My name is Salam. I'm from Seattle Housing Authority. I just have a quick question about our applications to renew expired green cards or conditional green cards. Are they considered the same as new applications?
Thank you for your question. So the short answer is no. When people who get green card status, they get some cases, if they got it through marriage, that was recent, 2-year green card, and then they have to go through this process of making a permanent green card, which is 10 years. But most people get a 10-year green card, right? And then when it expires, a lot of people think oh, I've lost my permanent residence. No, it's sort of like your passport, right? Like your passport expires doesn't mean you're no longer a U.S. citizen. It just means you have to renew the passport, right? And so it's the same thing with the green card. So people should not be worried about this being an issue when they are renewing their green card, because the grounds of inadmissibility, public charge does not apply in that situation, right? I always do warn people, green card holders do have to worry if they've had problems with the criminal justice system in that situation, because that is one situation where the government sometimes runs a new background check on the person. And so let's say that I got arrested for a drug offense, a couple of years ago, and it was never an issue. If I'm a green card holder, right, and immigration never noticed, didn't do anything, I go apply for a renewal of the green card, right? That's when immigration finds out that I had this conviction that may make me deportable, right? And so there are some risks for green card holders sometimes at that stage, but not with public charge, okay? So I just want to flag that, yes, sometimes there is a risk, and we do ask people that if they had contact with the criminal justice system, that they consult with an attorney about renewing their green card. So there is some risk sometimes, but not around this issue, not around public charge issues. All right, Joaquin, you're up.
So Luis, who is watching via chat or via Facebook, wanted to know what in detail, how does the abroad consulate official interview you regarding this? Is it a form you fill out? What's in summary, the process that someone can expect if they're at a consulate applying for entry into the U.S.?
Yeah. So, well, the first thing I would say for anybody who's doing the consular processing, frankly, any kind of immigration application, really encourage people to make sure that they're going with an attorney or an accredited representative. And, I work for a nonprofit agency, so trust me, it's not because I'm trying to generate more business for us. We would be happy if we didn't have more work to do. But the reality is, particularly with these rules, it's just very risky to go on your own. So I would just encourage people who are watching to make sure that they consult with somebody if they're going through something like consular processing. So what happens is that they do have to, you have to fill out a bunch of forms as it is already, and they just put into place a new form. I believe the name is DS 5524, Department of State form. And that is a new, I think it's 12 pages or something, that asks all these extra questions about your immigration. It's literally called public charge questionnaire. And it just asks all these questions that we've talked about your age, your employment history, your income, your household. And so, yes, they're going to be asking all those questions. And on top of that, as we talked about earlier, there's the medical exam that has your medical history. And so all of the issues that we talked about earlier are going to be covered in between all of those forms. And that's where the issues are going to come up, and where the consular officer, when they go to an interview with the applicant for an immigrant visa, is going to start sort of looking and going into depth about what issues people might have and what why the person may be deemed a quote unquote a public charge.
And then Anika also had a question about just confirming receipt of SNAP, Section 8, or other benefits would potentially prevent an LPR from re-entering the U.S. if they leave for more than 180 days. And this is for green card holders who are eligible for those benefits.
Yeah, so in theory, that is correct. So if somebody is a green card holder and they have been receiving that form of public assistance, and then they leave the United States for longer than 180 days, then they become subject to public charge rules again, right? So as an attorney, I would have to tell them there is a risk that that could come up. And the way it would come up is that when you return and the immigration officer at the border says like, well, you've been outside the country 180 days, and now we're going to potentially put you in a deportation process to determine whether you're admissible or something called deferred inspection. And so, you know, how likely is that to happen? I think it's very unlikely, but I have to tell people that there is a risk. And so I always tell people who are green card holders, please try not to leave the country for longer than 180 days. And if for some reason, like a family emergency or something, you have to, then try to consult an immigration attorney before you spend more than 180 days so that you understand what the risks are and how you might be able to sort of mitigate any harms in that situation. So yes, unfortunately, there is a greater risk because of these new rules, but I also don't want to sort of like cause a lot of fear in people because I think we'll have to see how tightly they're going to interpret those rules. Are we going to do one more?
Sure.
Okay.
Ingo wanted to know what we can do to oppose the potential expansion of the public charge grounds of deportability for green card holders that you mentioned earlier.
Sure. Well, so again, that proposal has not even been officially proposed yet. So I mean, the administration has acknowledged that it's in the works. And so at some point, it's going to be put out in the Federal Register, and they will have to provide an opportunity for notice and comment period. And so that will be the opportunity when people can speak up, and I hope people will speak loudly against that proposal. We'll just have to monitor. People sign up for our email list at NERP, and I'm sure OIR and others will distribute that information. So we just need to be paying attention to that, and we hope people will certainly speak up against that proposal. So we're wrapping up on time here. Let me just close by, again, thanking all of you for being here and spending the time learning more about this issue. For those of you that are watching, I appreciate your taking the time. And again, we're going to be learning more about these issues. So I hope you see this as a first opportunity to learn more. We'll be providing updates as we get them. And again, thank you for all the work that you do serving immigrant and refugee communities as well as the entire community. We deeply appreciate it. Thanks, everybody.
Thank you, Jorge, and thank you, everybody.